Hello, everybody. Gbenga Olatunji here, welcoming you to GGM's Associate channel. We are looking at business law today. Business law is what we'll be looking at, and basically the objective of this video is to familiarize ourselves with the expectation of the institute concerning us. As business finance person, accountants must be well grounded in business law as it relates to them personally, their career, and the organization in which they are either employed or building up. So, business law is of great essence to any business finance person and accountant to understand and have knowledge of. We'll be taking a look at the breakdown of the topics, looking at the jugulars in form of the coverage, jugular breakdown of the syllabus, and also we'll go into a bit of detail of the topics, introducing ourselves into it or familiarizing ourselves to it, not necessarily going into details in this video because we have a lot of coverage before us. Okay, having said that, we'll be looking at the court system and the legal system, depending on wherever you are hearing me from. If you are listening in Nigeria, we'll be looking at basically the Nigerian legal system and the court system, which is fundamentally applicable to almost, it's more or less universal. Okay, then we will look at partnership, company, and insolvency law. We're going to look at criminal law. We're going to look at law of commerce and transaction. These are the jugular breakdown of the syllabus, not the topics. We are going into the topics soon. Employment law, law of trust and administration of estates, and we are going to look at alternative dispute resolution mechanism. Alternative dispute resolution mechanism. So let us go in detail of what is before us. So if you are just joining us on this channel, don't forget to click the notification button and subscribe so that new videos you are going to be informed on time. So the breakdown of the business law and the weight it carries in the syllabus as follows. The Nigerian legal system and the court system is 5% of the syllabus. Partnership, company, and insolvency law 35% of the syllabus. Criminal law 10% of the syllabus. The law of commercial transaction 35% of the syllabus. Employment law 5%. Law of trust and administration of estates 5%, and last but not the least, ADR, that is alternative dispute resolution mechanism, 5%. Really, we need to concentrate on them all. We must not say it's 5%, it's 10% and the like, even though this is guiding us to know how to read and time allocation, even in the exam, time allocation when we are reading, and our energy dispensation towards the syllabus and towards topics under each jugular. Okay, so the full details of the syllabus now. So basically, we have 17 topics ahead of us. The legal system, the company law, so we'll be looking at the types and the formation of company, like limited company, liability company, partnership, and the like. So formation of business organization, we must have knowledge of it. Management and floating of company, how to establish and run a company, and laws that we must abide with. Insolvency law, criminal law, law of contracts, or free or fraud and the like. We must understand them. Agency, law of tort, sales of goods, hire purchase, insurance and banking laws, negotiable instruments. The knowledge is not negotiable. We need to understand it. Checks, employment law. We need to know administration of estate and trust, and last but not the least, alternative dispute resolution mechanism. We must familiarize ourselves with it. So we are going to pick it one after the other, the Nigerian legal system, under which we need to know what is law. Really, what is the essence and the purpose of law? So we'll be introducing ourselves to the legal system and court system. The source of law in Nigeria. Basically, the source of law in Nigeria is English law, because after the colonization, they we adopt, not adapt, we adopted the law from Britain. Okay, so basically, the primary source of law is English law or legal system. We are going to go into it in the details. Then we'll be looking at on other sources of law in Nigeria, like our coming from the traditional background of our legal system and like sources of Nigerian law, common law, the doctrine of equity, which basically is coming from the primary law, primary source of law that we have, that is the English law. Doctrine of equity, statute of general application, Nigerian legislation, customary law, that's traditional law, that's another source of law, judicial precedence or case law, hierarchy of court, that is the system in place now, international law, how to relate to it, international law and infringement, legislative processes, we must have knowledge of it, division of legislative powers between federal and state governments, distinction between the civil and criminal law. We need to have knowledge of all these and many more. So the next one is about the formation of business organization under company law. So under this, we'll be looking at types of business organization, so proprietorship, partnership, limited liability companies, what are their functional classification, the procedure for formation of business law with Corporate Affairs Commission or the Register or Registrar of Business in the country. Lifting the veil of incorporation, when can we lift the veil of incorporation? We'll be looking at CAC function of Corporate Affairs Commission, rather, who is a promoter or who are promoters, duty of promoters, remedy for breach of promoters duty, pre-incorporation contracts that promoter has with the organization as an entity on its own. We must have knowledge of procedure for formation of companies too, like in form of documentation of incorporation, memorandum of association, article of association. We need to be well grounded in its effect of having a registered organization and registered company. We must have a knowledge of them. We must understand the multi-choice diversity of types of business formation that we can choose from, their advantages and their disadvantages and the like. Then we move on to the next topic, which is about the management and floating of a company. Management and floating of a company. So we'll be discussing the management's power, and how management team could exercise their power and authority. The power of the board, types of board, power of general meeting, importance of minutes of meeting, meeting of companies and notice of meeting, and how important notice must be served before a meeting could be held, types of meeting that a company could have, importance of annual general meeting, annual returns filing with the registrar of company, appointment of company's director, their status in the organization, their duties, their responsibility, their roles. We need to have knowledge of it and how to enforce the duty of director and ensure there is no intervention or undue influence around them. They must be independent as much as possible, especially the type of directors that is called independent director. Company secretary and his or her duty and obligation. We must have knowledge of it in business law. Company record keeping, who is to keep it, that is the secretary in particular, and when should we file, what must be filed on behalf of the company must be looked at, and we must have knowledge of it. Company audit must be looked at, company capital and security and the like must be looked at, how to maintain our capital so that it will not be eroded, and when it's eroded, what are the things that we can do, and the disclosure and the like, the venture, and how to wind up companies, because company has life of its own and any organism can die. So likewise, an organization could be wound up. So if we are winding up an organization, what are the things that are expected of us? What is a share of a company? Why do we need to have a share? How should we account for share of organization? Types or classes of shares, we must understand them. What is authorized share capital, nominal share capital, minimum capital, minimum authorized share capital, issued share capital, transfer of share capital, fully paid share capital, capacity of to transfer share capital by the organization, and when we are transmitting the or transferring or transmitting the share from one person to the other or from one shareholder to the other, what are the relevant things that we must lay at heart. These are many more are the things that we must understand. Debenture, we must understand types of debenture and how to go about debenture. The importance of federal high courts when we are winding up a business organization and winding up processes, voluntary winding up, compulsory winding up, and the like. We must have knowledge of them all. Then we'll go to the next topic, which is insolvency. Insolvency. So when we're talking about insolvency, we need to know the meaning of insolvency, or when we say an organization is insolvent, that is basically not being able to meet up with its obligation at the rightful time. So the scheme of arrangement and fixing and floating of charges. So we need to understand the processes of insolvency and how an organization can go into being bankrupt. So we need to familiarize ourselves with insolvency procedure, even accounting for insolvency and dissolution. Basically in accounting we call it accounting for dissolution of organization. So we need to familiarize ourselves with it. So the powers of the receiver. Who are the receivers? What do we mean by receivers or receivership? We need to understand it and familiarize ourselves with it under insolvency law, we need to understand agency of receiver, the duty and responsibility of receiver, and the preparation and filing of accounts, realization of debenture shareholders' security, and how to distribute the proceeds of an insolvent organization, and many more all will be covered in the course of detailed processes and detailed topic when we begin to have the topical lectures on it. So we move to the next topic that is expected of us, which is criminal law. The criminal law, we need to understand criminal law very well. What is theft? What is criminality? What is fraud? What is bribery? We are to add what is corruption and the like. So I'm talking about theft, you must know when we are talking about theft, taking what does not belong to us, converting it, elements of fraud, things capable of being stolen, punishments, false pretense, cheating, forgery, fraud, fraudulent, false accounting, and the like. You need to know elements when you are talking about bribery, elements that are common to being used to bribe and the like. Money laundering, limitation of amount of cash payment, identification of customer, and these are the roles that some agencies and institutions in the country need to play. Special surveillance of certain transaction, and that is why in countries now we begin to have bureau of public procurement and the like, just to ensure that this aspect of surveillance and monitoring is well catered for. Mandatory disclosure by financial institution, surveillance of bank accounts and the like, offenses and how they could easily be punished, just to ensure that everything is well with the economy. And we must have the knowledge of all this so that even we as business finance and accountants will not violate unnecessarily and find ourselves, whether intentionally or not intentionally, falling victim of certain infringements. Electronic evidence also too, when we are transmitting and transaction and having our transactions online and the like. What are the things that we need to be well guided of, and how we can use electronic evidence to support our arguments of fraudulent transaction against our business and the like. The email admissibility of documents, electronic documents in particular, admi- admissibility of evidence when it comes to website posting, web page and the like. All these things that normally we do and look at, they are admissible in the court of law. Evidence even from our GSM phones and the like, ATM, e-signature, proof of electronic signature and the like. So these are things that we need to familiarize ourselves with when we are talking about criminal law. Then we are going to move on to another one that is very important to us as accountants, talking about law of contracts. Talking about law of contracts, we need to have knowledge of its definition, the purpose of contracts. Why do we enter into contracts? What are the parties to contracts? Offers and acceptance, electronic contracts, offer and acceptance of electronic contracts, consideration, performance, liability and damages that could arise, how we can sign and administer digital signature, terms of contracts, exemptions, clauses here and there, and how to incorporate them into our contracts, discharge of contracts, remedies to breach of contracts, and a host of other that we are going to go into details, like liabilities and damages and how to resolve issues that may arise as a result of us entering into contract with other people. That surely in business we must enter into contracts. Then we are going to go into the law of agency law, and even for us as an employment accountants and employment, we are serving the capacity of an agent. So agency law, we need to understand how it affects us personally, the capacity of an agent, classes of agents, how we can create agency, forms of authority that agents do have, rights and duty, termination of agency, effect of the contract of agency contract that we have with the superior partner and the like. Must have knowledge, guarantorship in agency trust, bailment, the master servant relationship. You must understand very well classes of agent that we could have or fall into, the factor, the broker, auctioneer, decadere agent. We need to understand these types and classes of agents and what and when they can arise. Appointments in agency, necessity, extupel, and many more that we are going to look at in details. Forms of authority, we can have some authority can be given us by implication. We call them implied authority. Some are actually expressed and they are actual. That is, they are actually deliberately given to us as we know we have the authority to perform in these regards. The right of agent, duty of agent, the principal duty of agents will be looked at, act of the parties to agency, and every other operational laws that relate directly to the agency law will be looked at. Moving on from agency, now we'll be talking about the law of tort, capacity in tort, forms of liability in tort, negligence, products liability. Even in the first place, we need to know what is tort by itself. What is tort? So we are going to answer it in details. It's part of the knowledge that we must have. Then duty of care, breach of duty of care, damages, vicarious liability, liability by itself rather, strict liability, capacity in torts, and many more are what we are going to examine under the law of torts. Then we move on to the next topic, which is sales of goods. Sales of goods, the law that covers sales of goods, and in this our dispensation, sales is no longer limited to the physical. We have electronics sales. In fact, more sales are happening electronically nowadays more than the physically purchased goods and services being rendered. So we need to have the knowledge of the law as it relates to sales of goods and how it affects us. So what is the definition of goods, or what are goods. So the distinction between contracts of sales and other forms of sales that we may have: elements of sales of goods, transfer of property and possession, reservation of the right of disposal, that is the right to possess something and the right to dispose it of, the consequences of sales after we've sold something, what happened, transfer of title, performance of contract we've entered into, that is sales performance and sales contract, the rights of the seller, the right of the buyer, hire purchase, the right of the hirer, the right of the hiree, contract of sales and pledges, contract of sales and bailment, contract of sales and mortgage, and many more that we must have knowledge of in business law as finance people and as account. Then we move on to hire purchase itself as a topic, and we need to know what is hire purchase, the nature of hire purchase, elements of hire purchase agreement, the duty and the rights of parties under hire purchase contracts. We need to familiarize ourselves with termination of hire purchase agreements, the third party in hire purchase, the right of the owner and the right of the hirer against third party, remedies if we have breach in the hire purchase agreement that we are actually undertaking. Then we move on to insurance, and this is another aspect of business that we must not overlook. So we need to have the knowledge of marine insurance, the proposal form, what is utmost good faith in law and in law of insurance specifically, then insurable interest, subrogation, indemnity, assignment of insurance policy, double insurance, what's the consequences, or what are the consequences of double insurance rather, and contribution. The fact is this is to familiarize ourselves with the topics and knowledge that are expected of us, so we understand that we may have a lot of questions as we continue. So you can drop it in the comment section so that we can discuss it. But you can be sure of one thing, that topics will be undertaken and discussed. So this is just to familiarize ourselves with what we need to know, so that if you hear something, you know that at least you know that under business law it should be covered. That is the purpose and essence of this video. Okay, so continuing insurance law now, we need to understand subrogation very well, indemnity, and what are the effects of insurance, acknowledgement of notice, its importance, and the like, among many other things that we are going to cover in the syllabus. Then we go to another important topic of banking. So banking law, the bank, what is the definition of the bank, and who are the bankers? So the bank and the banker, the importance of bank, the banking system, the banking business, bank customer, the rights of bank customer and the rights of customer to bank too, the statutory duty of licensed bank and the central bank of the country, e.g. the Central Bank of Nigeria. Then we move on to the next topic about negotiable instruments. Negotiable instruments. This is another important topic to us and we must understand it very well. So what is negotiable instruments and types of negotiable instruments? Attributes of a document that we can call a negotiable instrument. We need to know it. Definition of bill of exchange, parties to a bill of exchange, distinction between holder and bearer's bill, acceptance of a bill, how to endorse a bill, negotiation of a bill, you must have knowledge of it, and the capacity and liability of parties to a bill, the liability of parties, the signature endorsement, the implication of forged signature, and when we hold a bill, how to care for it and the implication of it, timeline, deadline, discharge of a bill, and the implication of bills being dishonored. And we are going to examine, among many other things not listed now, noting and protesting. That leads us to the topic on check. As business people, we are going to use check undoubtedly. So parties to check, differences between a check and a bill of exchange, or are they the same? So these are the answers that we are going to have when we go into details in under this topic. Then we'll talk about types of check, types of crossing, and how to cross properly, forged check, implication of it, material alteration on a check, promissory notes, holders of check and the implication of holding a check, countermand of payment, among many other things about check. Then an important topic too is the topic of employment law. The topic of employment law. We must understand employment law very well because it relates us very well. So, meaning of employment will be examined. Really, people can be working, but they are not in employment by virtue of the meaning of employment. So we need to know what employment really means so that we will know when some things are missing in our employment and how to quickly ensure that we get them before it's too late. So we'll talk about meaning of employment, formation of contracts of employment, forms of contract of employment, terms of contract of employment, probationary period, which may be different from country to country but must be within a reasonable period of time, duration, duty of employer, duty of employee, and how to terminate contracts of employment, among many other things that we are going to look at in details. If you are here to subscribe to Teaching Social channel, please don't forget to do that.